This conference is now being recorded.
Good afternoon. Thank you, everyone, for coming. Welcome to the New York ASBO webinar, Effective Recruiting, Selection, Evaluation, and Discipline of Staff. My name is Matthew Darius. I'm the Senior Staff Associate for Professional Development and Services here at New York ASBO, and I will be moderating today's webinar. Your speaker for today's program is Melinda Burdick-Bowe, an attorney with Hancock Estabrook. Operator assistance is available anytime during this conference by pressing £0. Questions for the speaker may be asked at any time by pressing £7 on your phone. You may ask chat questions at any time as well by using the chat window on the right of the main screen. I'll now turn the call over to our speaker. Melinda, please begin.
Okay. Good afternoon, and certainly appreciate the opportunity of being able to cover the material today that Matthew just mentioned. I have been targeted to address. And certainly this is going to be an interactive conversation, we hope. Otherwise, it would be a very long hour and a half otherwise. And if there are any questions that you wish to ask at any time, certainly as Matthew indicated, please just direct your question accordingly. I just wanted to tell the group a little bit about my background. I am an attorney here with a law firm in Syracuse, Hancock Estabrook. About 90% or so of my practice concentrates on representing public sector employers, including quite a few school districts in this area and in central New York. But prior to that, I did wear a hat that's a lot more similar to the hats that all of you participants have on today. I was the Director of Labor Relations for Madison and Idebosis for almost 20 years. And during that time represented about somewhere between 25 and 30 districts in all of their labor relations issues, including collective bargaining and grievance administration, grievance arbitrations. So I just wanted you to kind of have a sense of what my background was here. And as Matthew indicated, I'm going to be covering a portion of the overall certificate program in human resource management. And I've been asked specifically to speak to the area that school business officials are responsible for the most part in managing, and that is managing their non-instructional staff. Now, some of the comments today that I'll be making certainly are going to also have some application to any broader responsibility that you might have with your instructional staff, if you are responsible for instructional staff, or even in your interaction with other administrators in the school. And some also of this content, will apply to civil service employees, and some of it will apply to both civil service employees as well as instructional staff and administrators. Now, the first slide that I'd like to go to here is just really kind of setting the stage for a lot of what we're going to talk about today. And that is clearly for any of you who have been in your position for much more than 6 months to a year. By now, you have a good understanding that especially here in the state of New York, we have a lot of laws, both federal, state laws, regulations, as well as a lot of activity in the courts dealing with what rights public employees have, in particular school district employees. And so looking at the first few bullets that I've put on this slide for you to take a look at, we certainly know that there are a lot of state and federal laws that prohibit discrimination based on just about every protected classification here, including gender, race, disability. Most recently here in New York State, we've seen the New York State Human Rights Law broaden to cover individuals who might be genetically predisposed to certain diseases. And we've just had a recent amendment that extends the protection of the human rights law to victims of domestic violence. So again, a lot of categories where, depending on what you know, what you're privy to about a particular employee, can come into play as you're walking through the maze of managing that employee's performance, and particularly if you're going to discipline them in any way. The next bullet, what we know and understand again is that in New York State in particular, we have statutory obligations to provide certain due process rights to public employees, groups of public employees, including teachers, under the education law, that's Section 3020A, and civil service employees, that would be under Section 75 for covered civil service employees. And then finally, there's a catch-all bullet that you see at the close of the slide. And again, we have a lot of federal law that governs terms and conditions of employment for non-instructional employees, not the least of which is what's the minimum wage rate, although that really doesn't have, it does have application under the federal law, but the state law really does not apply to public employees here in the state. How many hours an employee can be asked to work, and, you know, during that time period, what kind of a lunch or meal period has to be provided. And as you know, most recently, a whole series of laws requiring certain leaves of absences to be provided to employees for various purposes, including under the Family Medical Leave Act. We have both state law and I think even under FEMLA some availability of leaves for new mothers who might want to breastfeed or nurse their children while they're at work. And we then go on to a host of other federal and state laws that deal with your obligations to make reasonable accommodations to individuals who might have disabilities. So that just gives you a taste of what I'm sure you already know that you're subject to and deal with just about every day. Just to continue down that list as far as other types of obligations that might limit or affect a school district's right to manage or promote discipline an employee. Some school districts, in particular larger districts that have a number of administrative positions that are not in any bargaining unit, you may see some of those individual administrators with individual employment contracts with the school district that provide certain rights to those individuals, particularly with respect to discipline or termination of their employment. And then very importantly, certainly an important role and function for most business officials, under the collective bargaining agreements that are in place with your unionized non-instructional staff members, we see a whole host of ways that contract agreement limits the terms and conditions of those staff members' employment, what kind of disciplinary procedures and protections they have to be granted in addition to Section 75 of the Civil Service Law. And then a very important factor, which most of you, I'm sure, have had some interaction with in the past, is posting and bidding procedures in those agreements that may actually obligate the district to select a particular internal candidate over an external candidate, depending on the qualifications and what seniority that individual may have in the district or in their position. Okay, and again, any questions as we go along, please feel free to chime in. Just generally, and this is something that I'm going to get into before, we also know that there's an obligation on the recruitment end that all of the business officials have in terms of making sure that when you're interviewing or evaluating candidates for employment, that you're performing the necessary reference checks and making sure that you check into an individual's employment history so that you can rule out any extreme negatives there with respect to bringing them on board as your employee. Okay. Limitations by law. Again, I'm not going to go through the whole specific set of laws that might in some way obligate you. This is, of course, dependent on what facts and circumstances that you're dealing with respect to, an individual employee. And again, most of these deal with prohibitions against discriminating against an employee based on some protected characteristic that they might hold under the law. There's a last bullet here that I think we should spend a little bit of time on, and that is, again, just like teachers who are required to have a particular certification to hold their position, a lot of the jobs that the non-instructional staff may hold also have some licensing or some registration requirements. including, for instance, bus drivers who certainly have to have the proper type of license and endorsements to drive buses and other vehicles, your nurses, occupational therapists, physical therapists, other health-related personnel. So that's a whole other layer that, again, business officials are responsible for evaluating and making sure that individuals hold all of the licenses or registrations that they need to hold in order to be qualified to perform the duties of their job. Okay. The next slide, just generally addressing some issues to really think about as it relates to the recruitment process and the interview process. A lot of the districts that we work with many times may choose to use both the civil service application and then they also have a separate district employment application that they also require a candidate to fill out. That is generally a good idea because I think the civil service application is designed for the most part to really ferret out whether someone has just the minimum qualifications that they need to have to take an examination, a civil service examination, or to meet the minimum quals of a non-competitive or a labor class job. I think a district application today can and should go a little bit more broadly to really flushing out an individual's employment history and their background. But along with that, whether it's just a civil service application or it's a local district application, districts need to make sure that they really stay on top of regularly evaluating those employment applications to make sure that they don't contain any questions that would be viewed as illegal or unpermissible to ask under federal or state law, especially because, again, we know we're in a state that has very broad protections under the New York State Human Rights Law. Some of those categories I ticked off before, like victims of domestic violence, that may not show up on an employment application. But I think, you just need to be careful. That's an example as these categories are added that you don't have something on a very old employment application. For instance, write down every single arrest that you've had over the last 20 years as opposed to perhaps just asking them to state, which you can ask them to state, any convictions that they may have in their background. So again, if you have a local job application or even if you're just using the civil service application, it's always a good idea to make sure you periodically review the application or have someone, whether it's your school attorney or someone else, review it for you. Another step to take in employment interviews, schools, again, are very much decision-making and sharing organizations. So a lot of times we find, particularly with some of the higher-level positions, that districts may be using employment, or rather I should say, interviewing committees, a group of 3, 4, 5 people in some cases to interview and to make contributions and offer opinions about who they would like to see hired for a position. An important responsibility is to make sure that any individuals who are participating in the employment interview process also are well-versed and are up to snuff on what the current laws would say it's unlawful to ask in an employment interview. And sometimes, I'd say that more likely what's apt to happen here is, maybe for instructional positions or administrative positions, we've seen some problems with members of that interview committee not being well-versed in asking a question that they really should not be asking under either the federal or the state law. And that's this slide that I go to, again, is to just make sure that all individuals that are charged with interviewing candidates are familiar with proper interviewing techniques and that they understand what questions are permissible or impermissible to ask. If you have a centralized human resources department or if this responsibility lies in your office as school business official, generally a good idea to create a list of standard questions that all of the members of the interviewing committee can see in advance and generally try to try to have the process work so that applicants are generally asked the same basic set of questions. Now, I just spoke to a group on Saturday, and I know, obviously, everybody understands that the evaluation process is going to take on a certain life of its own, depending on, the type of position that you're interviewing for, and also the skills and attributes that an individual brings into that process. So there are going to be some deviations. I think that's recognized. But I think it is very important. We've seen a lot of increases in applicants for employment filing discrimination complaints, particularly here under the New York State law. It's very, very easy for an applicant to get a complaint in the door. The intake process with the Division of Human Rights is there's a lot of latitude given to individuals who feel that they may have a viable complaint. It's easy to get a complaint in the door. So I think it's important, if you have that kind of a complaint, to be able to stand up and to show that, generally the interview process was standardized and the applicants were generally treated in the same fashion as far as what questions they were or were not asked. And again, subject to some reasonable deviation. And we know it's not going to be a cookie-cutter interview, but just to try to standardize that process. Okay. Now, one thing that we are going to be talking about a lot today is, pre-employment inquiries, particularly with respect to individuals who have disabilities. But there are some nice guidance documents out there if you're interested, whether it's just for your own information or whether you'd like to give some of this information to people who might be involved in the interviewing process. Both the State Division of Human Rights and the EEOC issue periodic guidance documents that actually go through and list what types of questions can and can't be asked in an interview process or on an application. And here's some quick examples of the types of questions that are viewed by both of those agencies as being impermissible. Again, asking if a name's of a certain nationality or ethnic background, asking about marital status, Mrs. or Miss, whether a candidate has children or doesn't have children, whether an applicant has ever filed for workers' comp benefits, and again, the question that we already talked about a little bit about, have you ever been arrested? So those guidance documents are really a nice resource, and it's something that, if you ever feel you have need or you feel could be of any value to you, certainly I think you can just visit their websites and you can locate those guidance documents there. Now, the area of managing employees who have qualified disabilities, whether it be under the Federal Americans with Disabilities Act or under the State Human Rights Law, this is a very complex area of law. And the problem with this is that usually there's so many different issues that are converging all at the same time. When a district perhaps has information that reveals that an employee is experiencing a disability. What can happen here is that you could have certainly an employee who's making a request for family medical leave time at the same time. You could have a situation in which an employee has filed the claim under the workers' comp law. You could have a situation where perhaps, you're not getting a lot of cooperation from an employee as far as giving you adequate or complete physician certification to give you a good idea of, how long they need to be out or perhaps what type of an accommodation that they might need in order to get back to work. So it is very complex, and this is probably one of the most difficult areas that most school district employers have to deal with whether it's with respect to teachers or non-instructional employees or other. Again, one thing to think about in the interview or the pre-employment context is that when you're going through the initial interview before you've made an offer of employment to an individual, the employer is very limited in terms of what information it can seek about an individual's disability or whether they're capable to perform the functions of their job. Generally, the rule of thumb is that employers can only ask job-related questions. And the best example of how to really pose a question is if you have an essential job function. For instance, you're looking at hiring a custodian or a cleaner or a courier or a grounds person who needs to be able to come in and lift, whether it's 30, 40, 50 pounds, whatever it is. It's very important to let the individual know up front, first of all, that that's an essential duty of the position, an essential job function. And certainly you are permitted to ask that person, explaining this job requires you to lift a certain amount of weight, and can you do that, whether it's with or without a reasonable accommodation. Now, if that individual says to you, I absolutely cannot, and they don't qualify it in any way, that can possibly be a bona fide employment basis to deny that individual employment. However, if they say to you, and this usually doesn't come up in the case of a lifting requirement, but maybe it's a case where, there's a requirement of travel, or there's a requirement, say, of being able to stand for a certain period of time. If that individual says to you, well, I can stand for 4 or 5 hours, I just need to be able to have like a 10-minute resting period, that probably is going to be something that you're going to need to consider and to decide whether that's a reasonable accommodation and whether that person can be hired, even if that accommodation is something that needs to be in place for them. Now, the context of inquiries about an employee's disability can change. There is a basis under both the federal law and under the state law that you can make further inquiries and even require a medical examination as long as you've already made a conditional job offer to an employee. And we ran into problems, I remember, years and years ago where a lot of districts, because physical exams apparently were a lot cheaper then, most employees walking in the door, even before they were given an offer of a job, were asked to go through a basic medical examination. Today under the law, what we know is that generally you have to be in a position where you're basically offering that job to an individual as long as they can satisfactorily qualify on a job-related medical examination. And a lot of school districts, I believe, are right now limiting examinations, perhaps because of cost or some of the interaction with, dealing with some of the limits because of the ADA and the state law. And a lot of the districts are really limiting this to more individuals that they really need to either administer the exam for by law or regulation, for instance, bus drivers, perhaps cafeteria workers under the public health law, maybe teachers because of the long-term involvement and interaction that they have with students. But again, the basic rule of thumb is really that medical examination, first of all, should be a requirement for all entering employees in the same job category. So, if you're talking about food service workers or teacher aides, teaching assistants, bus drivers, all of those new employees should be treated similarly as far as exam. You can't pick and choose who you're going to give an exam to. And if you do have that information, if your health office or the physician, your school physician is performing those exams, and a very important requirement, and compliance I don't think is still very good in the schools, is that any information of a medical nature, certainly a physical examination result, has to be maintained somewhere other than the individual's personnel file. So in a school district's personnel records, you should see a personnel file, but that personnel file should not have any of the medically related information, such as physical exam results, certifications from a doctor, return to work statements, anything like that of a health-related medical nature should be maintained in a separate file so that if someone just wants to go in and look in the personnel file, they don't have this entitlement to look at whatever's in their file that's medically related. And again, any information that's obtained, again, the law says that its use is going to be limited to a non-discriminatory manner. So again, it's not to be used, in order to decide how you're going to treat an employee necessarily. It's going to be dealt with on a need-to-know basis. Okay. Now, I know that all of you spend a lot of your time working with the civil service, the local civil service commission, whether it's county, city, some other local jurisdiction, as far as making sure that non-instructional employees are appropriately qualified, if necessary, that they're taking the right test and they're being appointed off a list if they're a competitive employee. And I know that over the years, probably this was one of the largest frustrations, especially for school districts today, who are trying to compete with private entities for really in-demand positions like technical titles, computer personnel, sometimes nursing employees, because we all know that nurses are sometimes very difficult to find. And of course, one of the frustrations is sometimes the slowness of the civil service process in terms of if there's not a current list, certainly ordering an exam, then making sure, that the exam results are in, that a canvas occurs, and that a list is certified to you, and finally you have this list of individuals that you're able to look at to fill a new position. And this is all occurring at the same time that maybe your private sector competitor is just out there interviewing and making a pretty quick offer of employment. I just wanted to give you a little bit of background today. I know we have a limited period of time to work together, but certainly if we have some newer business officials, I think it will be valuable to go back and refer a little bit more in depth to some of the slides that you have here in your materials. Certainly, to the extent that you're going to be creating a new civil service position, that local civil service jurisdiction will require you to submit information. It's usually a new position duty statement that generally describes the duties of the new position and also what the district believes the minimum qualifications and a suggested title should be for that new position. The civil service jurisdiction will then evaluate that request for a new position and ultimately has the accountability and the authority to decide whether, that position should be, say, a teacher aide versus an office assistant one, depending on what you've described in the new position duty statement. One other area that you have to deal with the Civil Service Commission is the reclassification of existing positions, and this happens more and more frequently these days. Sometimes you may actually get a pretty active situation where either an individual employee or the union that represents them believes that their job title no longer adequately reflects what they're actually doing for the district, that the duties and the responsibilities have changed considerably. And so you may get some lobbying to reclassify that position to another title, and not surprisingly, that's usually a title that falls a little bit higher up on the food chain and would have a higher rate of pay associated with it. Now, again, if this process is triggered, and if there's an incumbent in the position, then the civil service jurisdiction has to notify not only the school of the request to kind of evaluate the classification of this job, but also the incumbent in the job, and provide an opportunity for both of those parties to submit further facts in writing before the jurisdiction, the civil service jurisdiction, takes any official action. We have had situations in which districts have ended up getting a result that they're less than thrilled with. Sometimes they don't necessarily agree, with the decision-making process, but sometimes it has a lot to do with the fact that reclassified title is usually a higher-paying position. And this is something that a lot of school districts may not realize, and sometimes I wonder if the Civil Service Commission really recognizes this, but if that reclassified position, the determination comes back, the Civil Service Commission says, well, we no longer think that, this is a custodian position. We think it's a senior custodian position. The legislative body does not necessarily have to elect to create that reclassified position. If they decide, because they don't want to spend the money, that they're not going to create that reclassified position, they can reject it, but you need to make sure that if they do that, then the duties of that position are refined and anything that's really out of title is taken away from the job of that individual. Otherwise, you're going to continue to have a viable claim here that that person is working out of title and that the job really does need to be reclassified. So there is some authority, so we've had some activity on this, not a tremendous amount of activity, but it can be a problem, particularly if you have an incumbent who's already in that job. One of the things that we suggest, and this really ties in some of the other things that we talked about, is that when a school district is beginning to create a new position, or whether you're evaluating if you're going to fill a vacancy that comes due, someone's resigned or retired, that's always a good time to review the job description or the civil service spec to make sure that it adequately covers the job duties and the functions that you need that position to perform. This is also a good time to make sure that any of those essential functions that we talked about are incorporated in the job description or the civil service spec. For instance, the lifting requirement. And, one thing, some districts, again, don't have an internal job description that they adapt or maybe elaborate on what they really expect for some of these types of unique essential functions. But if all you have in place is a civil service specification, you typically, for instance, in a custodial job, you're not always going to see, that lifting requirement adequately spelled out, especially the amount of weight that you may require. So, again, if you've got somebody who's involved as, a custodian and they're regularly transporting very, very heavy, cafeteria equipment or computer equipment from place to place, you're certainly going to want to try to look at adapting those civil service specifications to meet your local needs. Now, you can't really change the overall nature of the job. You can't take a custodial position and add a lot of clerical functions to it. That would, again, create an out-of-title situation. But certainly just to set forth some of those important job functions that you really need the individual to perform. Okay, and it's a good time just to make sure that the job descriptions are up to date and accurate to begin with. Some districts, if there is a real question of, an employee is making some noise or the union is making a lot of noise, some districts will actually go in and conduct a desk review or a desk audit, actually sitting there and observing over the course of a couple of hours or even a whole day or two, although that's a lot of time spent observing, how much percentage of time an individual is spending on specific activities. So again, are they spending 20% of their time typing spreadsheets, 40% of their time answering their phone, et cetera, et cetera. That's a pretty typical activity that even a district could do. And again, sometimes in controversial situations, you may actually see the local civil service commission asking to come in, certainly asking to have questionnaires filled out by the incumbent describing what they're doing. But on occasion, they may actually ask to come in and observe a person and to see what that person is doing every day. So again, something that you really don't want to invite. So a good reason maybe inventory these vacancies as they come up. I talked a little bit before about references and backgrounds. I just want to point out that one of the reasons that we do spend some time counseling school districts about this issue is because here in New York there is an emerging area of law here that has found some liability, particularly with school districts or other types of institutions, that provide daycare services or, other services to children. And again, I think it's because of the potential exposure here of bringing an employee into that setting and just having this really sensitive population that they work with every single day. So here in New York, this is a developing theory of liability. I will tell you that employers in general are not going to overwhelmingly be found liable if, there's one particular gap of time that they don't investigate on a resume, particularly if there's no other information that's been made available, to the school district that would cause it to question, a gap in time. I mean, certainly when you're reviewing employment applications, that's always kind of a red flag. If you have a 2-year period of time on a resume or an employment application, that would be a good thing to ask the employee to explain when they're in the employment interview, so you can ferret out what was going on. Was the employee in school? Was the employee traveling, or was the employee incarcerated? Something certainly like that is going to jump off the page, and I think be something that any employer is going to be looking into a little bit further. But again, the general rule here is just reasonable care. Any employer needs to screen applicants for employment with reasonable care to ensure that they're competent and fit to perform the work that's going to be assigned to them. Okay. And again, there's not really even an employment relationship here necessarily for this type of negligent hiring. Sometimes a cause of action can even be brought against a school district, perhaps by a vendor who's in the building or a visitor in a building who ends up getting harmed in some way by an employee. So you don't necessarily even have to have, a special relationship with the individual who claims that they were harmed in some way by your employee. It could even be brought by a visitor or someone from outside of the school community. One advantage in schools, despite all of the hassles of working through this process, is that here in New York State, for employees who've been brought in since July 1st, 2001, all prospective school employees are now required to submit to fingerprinting and required to be cleared for employment by the state education department. So again, today we are conditioning offers to all new hires based upon them receiving the necessary clearance from the state education department. So at least there is an extra layer here of surveillance as a result of going through the fingerprinting process. Still doesn't mean that things do not fall through the loophole, because obviously we know that does happen. And then, of course, we know that even under the fingerprinting laws, you may have somebody who comes in the door being cleared for employment, and then a couple of years later ends up getting convicted, and, that shows up in the system, and you get some type of a notice from state ed just telling you, that the person has had a reportable conviction, and it may take you a long time to resolve exactly what has happened and to get to the bottom, of that developing situation with an employee who's already been with you for a few years. Negligent hiring, I'll just quickly go over this, a little bit further here, but generally what I wanted to say is any kind of a duly diligent reference check is a good defense for most employers today. The only reason as I said to you before, it's important to talk about this at all is I think just because of the unique nature of school districts and the fact that they serve children every single day, that if you did not perform a duly diligent reference check and you brought someone in as a cleaner and that cleaner happened to have an occasion to be alone with an elementary age student and harm them in some way, that can be a problem for an employer who just happens to fall into the situation of having that person on board as an employee. So again, perform a diligent reference and background check for any candidate for employment with the district. I think that's the bottom line. And as long as you're doing that, I think that generally provides the type of defense that a district would need to be able to stand up and say, look at, we checked references, we interviewed them, we looked through their application. There's no way that we could have known that this particular individual is going to do what they did. And, it's an area of concern, but I think, again, it just really emphasizes the need to be very thorough in your evaluation process. Negligent referral, sometimes we get questions. There's always tension. If you have an employee, particularly someone who is discharged for less than stellar reasons, as to what a school district is obligated to tell other potential employers about what that employee did when they were working for them. I know school districts have obviously a conscience. They're going to try to make decisions, hopefully good decisions about what they will and won't share. On the other flip side of the coin, I mean, obviously we always have concerns too if an individual is leaving under less than stellar circumstances. School districts are obviously usually very grateful for the fact that there's been that separation of employment, and they're happy to see the person go on their way. The good news, if there is any, is that here in New York there really is not a large basis of success in claims that are being brought for negligent referral of individuals for employment. So even if it were a case where a school district perhaps said maybe less than they know about an applicant, as long as it doesn't, fall into this whole area with teachers, this whole prohibition under education law to have a silent resignation when there's some kind of a sex offense, as long as it doesn't fall into that territory, again, there's some insulation here, even under New York State law, that you don't necessarily have to share everything you know about a particular employee. Okay. But again, it's a very case-by-case circumstance, and if you have a case that's dicey, it's certainly a good idea, again, to always run it past your school attorney if you've got concerns about this issue. Again, just some pointers here, and I'm not going to spend a lot of time going through this. We've already talked about most of the suggested strategies here to avoid negligent hiring problems. And again, just to have a complete recruitment and interview process where you're kind of dotting your I's and crossing your T's and reviewing the applications very thoroughly. And this covers most of these points that we were talking about earlier. One thing that I do like to say is there has been a real ramping up under the New York State correction law as to how an employer needs to evaluate a candidate for employment that comes to them who does have some history of a conviction in their past, okay? And again, it is certainly permissible to have a question on an application or to even ask that question during your interview about whether the applicant was ever convicted of a crime and during a certain period of time perhaps. If the answer to that is yes, and usually the question would go on to say, state the particulars, and let's say the individual claims that they were convicted for petty larceny 20 years ago, and the position that you're interviewing them for is working in an environment where they're certainly not going to have any regular access to monies, collecting monies, or anything like that. But best example might be they're going to spend all of their time maybe out on the grounds, cutting grass. Under New York State law, generally, what it requires an employer to do is to actually take that conviction information and really to determine whether there's a nexus between what they were convicted of and the job that they're going to be doing. And again, if it's even a DWI and the individual is not going to be obligated to drive a vehicle or operate equipment, probably too remote here to be a demonstrated nexus to rule that person out based on that reason. The other thing is certainly during this process under the New York State correction law, what that law requires employers to do is to also consider evidence of rehabilitation. So if an individual, again, comes to you and says, I had a conviction 15 years ago for petty larceny, there's no other conviction, perhaps that individual had to do some community service and they've done it, they've complied with all the terms of, probation or anything that they might have been held to, usually not for petty larceny, but for a more significant conviction, you might see that. If they show evidence that they've done everything that they need to do to rehabilitate themselves, and the conviction was a very long time ago, under New York State correction law and the way the courts are interpreting it is you're probably not going to be able to demonstrate that necessary nexus to keep that person out of the employment setting based solely on that conviction. Now, you may decide to not hire the person based on other reasons. Maybe they're not the best qualified person for the job. But as far as the sole reason being just their conviction status, that is not allowed under the correction law as it's written today. Okay, so something, and that correctional law provision, I think it was 2 or 3 years ago that it was really ramped up to actually set forth the 6 or 7 different types of things that an employer is supposed to consider when they're evaluating a candidate or even an existing employee's conviction. And so it's important just to be aware of that if that information comes to you through whatever source and you're able to confirm, that the individual did have a conviction in their past. Just to return to civil service law, again, we talked before a little bit about the civil service process and the process of classifying positions. I want to talk to you a little bit about the classification system, just again, to kind of level the playing field. I know we probably have some very experienced school business officials and maybe some newer school business officials. Hopefully, if I'm saying something that you already know, you can forgive me, and this will serve as maybe a good refresher. But I just want to level the playing field and just kind of talk a little bit about civil service classifications. Classified positions, basically, that's going to include everyone other than a very small group of titles that are in the unclassified service. And the unclassified service is usually anyone who's an elected officer, certain department heads, very high level, and all of your certificated teachers, teaching assistants, and your administrators in schools. So you are going to have a pretty good segment of your staff that are not going to be classified civil service employees. But again, for most of the employees that school business officials directly supervise, most of them are going to be in the classified service, whether they're in an exempt category, competitive category, non-competitive, or labor class title, okay? And this exempt category that I just ticked off, sometimes this is kind of like the big fuzzy area. But again, any positions in the exempt class do have to be approved by the local civil service commission as properly belonging there. And usually it's a very short list of folks who are either deputies who are authorized to act for department heads, and certain other types of appointed positions typically for which a competitive exam is not practicable. So in this exempt class, sometimes you may see a secretary to a superintendent of schools, certainly a school district clerk, school district treasurer, I think usually falls in that exempt category. And the reason for that is usually they're appointed to serve at the pleasure of someone else. And so there is an avenue, basically, for that person's employment to end without respect to civil service, process for removal or discipline. A lot of the positions that you're going to be responsible for overseeing are going to then fall in the non-competitive class. I mean, a lot of the positions are going to fall in the competitive class, but I think the next common class is the non-competitive class. And that is where a minimum qualification is established for the position, but it's just not, a competitive exam is impractical. There'd be no reason to test. Usually these are more of like a bus driver, a blue-collar position where, they come in, they have, some baseline qualification that they need to hold and maybe some experience driving. But other than that, really not much more. And there actually is also a labor class, which is relatively unskilled labor positions. Now, those positions really don't even have a minimum qualification attached to it as far as a job skill. Usually all that's required is just that the individual have a high school diploma or a GED. And the best example here are labor titles. Usually cleaners fall into the labor class, and as opposed to custodians who usually would be up in the competitive class. The general rule of thumb, though, is the presumption that most positions are going to be in the competitive class unless there's a reason to find them as not being practical to test for. So again, a lot of your positions, certainly all of your clerical positions, a lot of your higher level custodial positions, they are going to fall under this competitive class, and they generally are going to need to take a test be able to pass that and be reachable on a certified eligible list so that you can appoint them to the job. Usually entry-level positions are filled through what's called an open competitive or an OC exam, and usually that's opened up to anyone, who lives within a certain area, county generally, or a contiguous county, who meets the minimum qualification. So they just fill out an application, they come in and take the test, and then the civil service jurisdiction compiles the scores, and if you have a position, they're obviously going to canvass everyone or a certain group of people to determine whether they're willing to accept a job in your school district, and then they're going to, as a result of that, send you a certified eligible list that usually has the top 3 scoring candidates for you to pick from. In some cases, I'll just briefly touch on this. For some of the higher level positions, you will be working from a promotional exam list, and that's usually the case that you have kind of a promotion series of positions. You may have somebody going from custodian to head custodian, and a promotional exam is usually going to be administered first and given just to the folks who have prior service as a custodian for usually it's 1 or 2 years of time in your district. So it's going to be a limited field as far as who's able to sit for a promotional exam, and it's really going to limit the candidates who are going to be eligible to be appointed. And again, just like everything in the civil service system, we have 2 sides to every coin depending on the facts and the circumstances. Sometimes a promotional exam is a very good thing. Sometimes it doesn't really offer the breadth of candidates that you would like to see. So it really depends on, who's working with you at the time and who's eligible to sit for a promotional exam. And again, I talked briefly, again, most of you probably have a pretty good understanding of the testing process and the fact that when you get a certified eligible list, the requirement generally is that you have to pick from among the top 3 eligibles that are willing to accept appointment. That's the rule of 3 that we talked about. So there really is a limit, as we all know, in terms of who you can look at, and if any one of those individuals does not decline employment after you've interviewed them or somewhere along the process, then ultimately you're going to be bound to pick one of those 3 people. You can't go down and find that 6th or 7th person that you really know would do a good job for you, or you feel would be much better suited than even the 3 that seem to do very well on the exam. If there is no list, if there are not adequate candidates to produce a certified list of 3 candidates, then school districts do have a basis to make what's called a provisional appointment. And that's basically picking an individual who has not yet taken an examination, being able to appoint them to the position, but understanding that they're going to have to sign up and take the next offered examination, and the challenge is that that person's going to have to score high enough to make it into this rule of 3 that we just talked about. And I've got to tell you, in all the years of working with schools, probably the most difficult situation was where you had a provisional appointee who was a horrible test taker and just was never able to get anywhere close to the top 3. And sometimes these exams are not offered fairly regularly. So you may actually have this person working in the job. You may have invested a lot of time and energy and expense training the person to learn the job. They're doing a good job, and then ultimately you're not able to get them permanently appointed from a valid civil service list. So that is always a challenge, trying to get creative and to try to find some way to make that provisional appointee, successful somewhere in the school district. And that I'm sure is a continuing concern for most school districts. So, to the extent possible, try to appoint people when there is an active list. If you can't, hopefully you're going to have a person that you appoint provisionally who's going to be able to get in there and somehow qualify and score high enough to be appointed. Temporary appointments, I don't know if these rules are very well known, but again, any temporary appointment does have to be approved by the local civil service jurisdiction, at least with respect to whether the individual that you'd like to appoint meets the minimum qualifications for the position right up front. So based on their application, the local civil service jurisdiction will review their experience and their education to determine whether they're even qualified and meet the minimum qualifications for the job that they're going to be given a temporary appointment in. There is, under these 3 bullets, some limitations that exist depending on how long a school district is interested in having that person serve in a temporary appointment. And technically, although I'm not so sure that this is very well enforced across the board by the civil service jurisdictions, if someone is going to be appointed to replace an individual who's on a leave of absence, say, for an approved leave period of more than 3 months, then technically that individual is supposed to be coming off a list if there is one. Okay, and this is something that's always a bit of a surprise, and I'll be quite frank and say that I've never really seen an enforcement issue in the time that I've worked with schools on this, where the Civil Service Commission has said, you need to take this person off the list. I think one of the reasons is because many times districts may bring in a temporary appointee initially with the idea that they're going to be there for less than 3 months, and then additional leaves are extended or granted, and the person ends up being there for longer than that. So, if it has been a problem for anyone who's participating in the conference, that'd be something that I'd be interested in having you speak about. But, I don't know that enforcement has been especially rigid on this particular point across the board. And again, keep in mind that collective bargaining agreements can certainly give union members greater rights than they have under the civil service law to a vacancy or promotion, particularly based on seniority, or at least give a unit member some preference over a non-unit member, somebody from the outside. However, even though you might have language in your contract that conflicts with the civil service law, if you have a competitive civil service list and you have that rule of 3 to deal with, you might have poorly crafted language that seems to apply promotional preference to senior bargaining unit employees, but if they're not on that list, civil service law is still going to trump that language. And we've had some cases where, we've had to basically take a position that the contract language is void as a matter of law because it doesn't stand up under the Civil Service Law Rule of 3. So if you don't have an active list, all bets are off, or if it's a non-competitive or a labor class position, which is usually where you see a lot of the selection procedures under contracts come into play. Obviously, for a non-competitive or a labor class position, if you've agreed to language and it says, bargaining unit members have a right to bid for openings, and the only thing that will be considered is seniority, it's an absolute seniority clause, then if you have 4 employees within the unit who bid, you have 2 from outside of the district. If you've got absolute seniority language in there, then you're stuck ultimately picking that most senior employee. I think most school districts that I've worked with have at least a hybrid selection clause or provision in their contract that may say that either other factors are also considered side by side with seniority, and only if everything's equal will seniority be the deciding factor, or maybe even more watered down language. It just simply says that seniority will be a consideration, but it doesn't particularly have any convincing weight in the decision. It's just something that has to be considered. This is a prime area for grievances. Especially today, it seems with a lot of the unions that we're working with, if an employee is disgruntled because they are not picked for a position and they feel, I was the most senior employee, I put my time in, I should have been picked, so-and-so is not any better for the job than I am. If a grievance is filed, a lot of the unions will take these grievances to the mat because they're concerned that they may have a duty to represent, one unit member, even if that person is bringing a grievance that conflicts with another union member who got the job as a result. So we're seeing, we have always seen a lot of activity with this kind of language that ends up in contracts, particularly if the language is less than crystal clear. It's ripe territory for grievances. Appointment of civil service employees, again, just want to briefly point out, as I'm sure most of you know, that under the civil service law, once an individual is appointed to a competitive, non-competitive, or even labor class position, they're required to serve a minimum probationary term before they become permanent. And generally, although the local rules can differ for specific positions, the general rule is a minimum of 8 weeks of probation and a maximum of 26 weeks or 6 months. That is the standard rule. Now, can a collective bargaining agreement provide a greater period of time to be served for probation, or can a collective bargaining agreement require that unless an employee has demonstrated performance problems, that the district permanently appoint them after 8 weeks? Yes. Contract language can further obligate or further prescribe what this probationary period actually is and how it ends up working. But the general rule of thumb is a minimum of 8 weeks and a maximum of 6 months of probation served in most of these positions. If there's a promotion, I think generally it's about a 12-week probationary period that someone is required to serve. It's not the full 6 months typically. But again, one thing you're going to need to do, if you have a question about this, is to consult the local rules for your Civil Service Commission. And most of the Civil Service Commissions and departments today usually post their rules right on their website. So if it's been a while, or if you've never taken a look at the local rules, it's never a bad idea to either visit the website and download a copy, or pick up the phone and ask the commission to send you a copy of the local rules, because sometimes these rules will be different from jurisdiction to jurisdiction. And the one thing that I'd like to say is that we certainly know that as far as the requirements for notice when a school district wants to terminate a probationer during their probationary period, the local rules will greatly differ. So it's important to look at the local rules because a lot of them may require that you give a minimum notice, say, of a week before you terminate a probationer's service, or provide that person with the right to ask for a meeting or an interview with a particular individual in the district. So, it's very important to check the local rules just to make sure, if you have someone during this probationary period that you quickly identified as not going to cut it, the last thing that you want to do is to give them something to argue as far as, the fact that they weren't terminated in accordance with the civil service law or rules. So just some advice just to become aware of those local rules if you're not already aware. And then the last piece under the local rules, again, check them because there is almost always a requirement that during the probationary period, a supervisor is supposed to be observing the performance of that individual and from time to time advising the employee of their status and progress. Your contract, your collective bargaining agreements can also have some obligations there that will trip your supervisors up as they're working through this process of deciding whether they're going to recommend that a probationer be permanently appointed to their job. So again, I think I would say that school districts, as far as an area where they may be lax, it is probably in terms of the work that they do with probationers, observing their performance and giving them feedback, doing evaluations during that period of time. So if you're trying to streamline resources and if you're going to spend some time and attention working with your supervisors on how to evaluate, this would be an important point to cover with them, that they should be in there meeting and observing these probationary employees so that they have something to back up a recommendation to you that they're not going to cut it and that you need to cut them loose before they become permanent. Discipline and discharge of employees, we're now at about the 3 o'clock mark, and I know that we wanted to end today at about 3:15 or so to allow for some time for questions. So I'm going to try to streamline through this a little bit, but again, if anybody has a question, please, just chime in, and we'll make sure that we slow down a little bit and get to exactly what you'd like to know. Non-instructional employees, again, we've already talked about the fact that civil service law is going to pertain, at least with respect to a good majority of the non-instructional employees that you supervise. There's one other area and topic that I'm going to cover today, and that is that employees can also be given extra protection under a collective bargaining agreement based on a just cause provision or some other language that might appear there that provides them, that says basically, that they can only be terminated from their job based on cause or just cause or for adequate reasons or demonstrated cause. The language may not always look the same, but it's important to become familiar with whether your collective bargaining agreement has that obligation. And sometimes it can be buried somewhere in 2 or 3 pages of language. So particularly if you're coming in brand new to a school district, it's always important to take a look at the collective bargaining agreements and become very familiar with what extra hoops you might have to jump through, and not always assume that the only folks who are going to be given a right to, a disciplinary hearing are just your folks who are covered under Section 75. Now, Section 75 of the Civil Service Law, as far as what that statute does as far as disciplinary protection, it covers, obviously, number one, permanently appointed competitive employees. So any of your competitive employees, the folks who are appointed off a list, once they've successfully completed their probationary period, and again, remember, that can be as little as 8 weeks or, as little as 6 months, they're permanently appointed, and at that point, they have a right to a hearing for any type of discipline from a reprimand all the way through to termination. Likewise, and this was an amendment to Section 75 for municipal employers, including school districts, I want to say 7 to 10 years ago, but it could have been even longer than that. Any permanently appointed employees who have served 5 years or more in the non-competitive class, whose position is not confidential or policy influencing, has a Section 75 right. Now that means that if you have very high-level personnel who, for whatever reason, are non-competitive, but they're really heavily influential, they're perhaps in a managerial, confidential type of position in the district, they would not necessarily have that right. And again, in your local rules, you'll see an appendix. Any position that's been labeled as being confidential or policy influencing is usually noted some way in the rules. So you're going to see a list of titles under the non-competitive class, and then you're always going to see some kind of an identification of who's confidential or policy influencing who would not have this Section 75 right otherwise. And then the third point that I want to make, because we've had a number of occasions where districts have been surprised, if you have in your service someone who may not be competitive, they may not have completed 5 years in a non-competitive job, but they are either a honorably discharged war veteran or an exempt volunteer firefighter, they also have protection under Section 75. So you need to look beyond just the surface of someone's appointment. And again, you got to look back at the application. Sometimes those civil service applications are going to clearly mark whether they're a veteran or whether they're an exempt volunteer firefighter. But if they don't, and if you're basically on the verge of instituting some pretty significant discipline, I would advise you to actually ask the employer right up front, to identify whether they are either an honorably discharged war veteran or exempt volunteer firefighter. Now, you may, the definition of what that means is in the law, so not everyone is going to be covered. But certainly, again, if you have a question, you'd need to look at the civil service law or talk to your school attorney or call your local civil service commission to get a better definition about who's covered as a war veteran or an exempt volunteer firefighter. But we've had a case where, one case I can recall where we thought we had done diligence, we preferred the charges, or we didn't prefer the charges, we were getting ready to discipline an employee, and then we started to meet with the employee, and the union said, wait a minute, this person's an exempt volunteer firefighter. So we had to stop and go back and do everything that we needed to do under Section 75. One thing to keep in mind is Section 75 doesn't apply to layoffs or job abolishments. So if you're looking at layoffs or reductions in position, certainly Section 75 does not come into play. That only relates to discipline. There is a section, 2 sections of civil service law that govern the layoff or reduction in force of competitive class positions only. In municipal jurisdictions, the only covered positions are competitive positions. If your contract is silent, then as far as the order in which you lay off or call back your non-competitive and labor class positions, that's totally up to the school district, as long as, again, you're not making a decision based on somebody's protected status under some other law. So the important thing to keep in mind is civil service law applies whenever you're looking at laying off competitive class positions. Again, if you're talking about laying off other than competitive class positions, you're going to need to take a look at your collective bargaining agreement to see if anything has been negotiated there that's going to govern in the situation. And a lot of times you're going to find that, you will see some rights there. They may be more limited than what's provided under civil service law to competitive employees, but there may, again, be some type of minimum notice of layoff or maybe some right for those employees to go on a preferred eligible list once they're laid off for a period of time. As far as the competitive class employee layoff, obviously we know that that is undertaken in terms of looking at seniority as is defined under the civil service law, and this is a very, very complex area. So if you are looking at truly laying off an employee, you're not doing your position reductions through attrition, the first call that we would usually suggest that you make is to the civil service jurisdiction to get them to give you a summary of the information that they have in their official roster for the employees who are in the job title that you're going to be impacting. So if you're looking at laying off a custodian, it would be important, that you know exactly what the civil service system has recorded as the actual seniority for all of the individual employees who are in that custodial title, because that's the ammunition that you need to really figure out who's the least senior and who are the folks who are going to need to be let go. And otherwise you're going to get caught, obviously, in some potential for someone who is improperly accessed to come back and to bring a claim, and that would also be a claim against the school district, as well as, seeking to bump somebody else out if they felt that they were more senior. So it's a very complex process. There is a whole manual that I think you can find at the State Civil Service Commission website that walks through at great length. I think it's about 40 pages long, how you basically look at layoffs and what services counted, what services not counted in determining seniority, certain types of bumping and retreat rights that competitive class employees will have under civil service law. So if you haven't had a reduction in force and you're going through it for the first time, again, it's going to require a little bit of research to make sure that you get your ducks in order so that you're administering this as you're supposed to under the law. And just cause, I think I've already given you some information on what that protection looks like under the contract and the fact that you may have to look for it a little bit in order to truly find if it exists. If you find a just cause right in your agreement, sometimes that language may be written that it's clearly an alternative to Section 75, that the employees have waived, the union has waived the individual employee's rights to a Section 75 hearing, but they've replaced it with a just cause obligation. And the meaning of just cause is, too, remember, they can file a grievance under this provision, and ultimately most labor contracts provide binding arbitration as the last step in that grievance procedure. So if someone has a property right because of a just cause provision in a contract, it means that they file a grievance, and ultimately some independent arbitrator is going to hear the case and issue a binding decision about whether there is sufficient cause to discipline that employee in the manner that the district decided to do. So and just a caveat to that, it's not always written as an alternative. And there are a lot of cases where a school district basically has to give an employee and their union 2 bites of the same apple. In other words, unless they waive their right to a Section 75 hearing, you would have to grant them a right to a Section 75 hearing and potentially defend a grievance at the same time. So that is, all the situations that you would have presented to you, that would be the one that would be the most burdensome. And hopefully, if you have just cause language, there's some clarification as to whether that means that they do or do not have a Section 75 right as well. And again, just cause, a lot of times what it does is it provides a due process right to, folks who would not otherwise be covered. Maybe they're a non-competitive class employee, hasn't been with you for 5 years. Maybe they're a cleaner, they're in a labor class position, so they would never have a Section 75 right to begin with. Typically a much broader right and a right that benefits a lot more folks in that bargaining unit than civil service law would otherwise provide. And I'm not going to go into this at great length, but the next 2 slides, if you are faced with a grievance that ends up before an arbitrator, here are the basic tests that an arbitrator is going to apply to decide whether the employer had just cause to discipline an employee. And most of these things, they deal with the frustration that you deal with every day, trying to get your supervisors to document the work that they may have done with a non-performing employee or an insubordinate employee to try to get them to improve some of the progressive discipline that they might have attempted. A lot of the case, whether it's a Section 75 case or a just cause case, is going to depend on the progressive measures an employer has taken before to try to get the employee to perform or improve. Because, again, if you're talking about disciplining a 15-year employee and you have absolutely no documentation of any kind of discipline before, and now you're trying to go automatically to termination based on, absenteeism or something like that, something other than an event that's pretty egregious, I don't need to tell you that you're going to have your work cut out for you, and most likely that arbitrator or hearing officer is going to look at that and say, no documentation that you've even worked with this employee. We would expect that the employer in this case should be limited to just maybe a suspension of a couple of days. Termination would be too great of a penalty under the circumstances. If you have a brand new employee and they're not performing, you may get some more leniency under these rules. But again, the general rule of thumb is, there has to be some evidence that the employee knew what they were doing was wrong, that they were violating some kind of a rule that they knew about, and then generally, was the fair investigation done? I think certainly the arbitrator or the hearing officer is going to usually be looking to see that the employer didn't rely just on hearsay, that the employer actually went out and investigated and confirmed that the employee did what they were alleged to have done. And again, one very important point is treating employees in a similar manner. If the employer has kind of turned a blind eye to conduct by 10 other employees and then all of a sudden decided to pull the lever on a particular employee based on the same conduct, then you're going to have a greater problem prevailing in your case than if you would have treated other types of circumstances and employees exactly the same way. And then the last thing is, did the penalty fit the crime? You know, obviously looking at the severity and the seriousness of what the employee did, the record of the employee, service with the employer, and coming up with a conclusion as to whether the discipline that the employer wanted to see should be implemented or whether it's too severe. Okay, the next few slides, hopefully you can use this in your work with your supervisors. These are all solid pointers as far as trying to document different types of strategies for making sure, you know, that you're working with your employees in a progressive manner. One pointer is, for whatever reason, sometimes we have supervisors who keep these lengthy working or desk drawer files. You know, they write down when they've spoken with an employee and they put it in their working file, but they never issue a counseling memo and nothing ever goes into the personnel file. And then, you know, 2 weeks later, the supervisor's in your office demanding that an employee be terminated because of all this hassle that they've gone through in the last few years. You open up the personnel file and there's nothing there. The supervisor says, well, I have all these notes in my desk drawer. Really is not going to be of a lot of use in terms of demonstrating, you know, that you've taken these progressive actions. It's not the type of documentation. If a supervisor is concerned and that performance doesn't improve, then they should be getting in the habit of writing counseling memos and putting those counseling memos in the personnel file. Because, again, generally, as some of these later slides will show, a counseling memo does not rise to the level of discipline under the civil service law, and usually not under most just cause standards. Counseling memos can serve pretty much the same purpose as a reprimand, but again, they're written usually by a lower level supervisor, and the tone and the tenor is usually, here's what happened, here's why that wasn't good, and here's what you need to do in the future to correct it. If you don't correct it, you may be subject to further discipline. But it really does not take on the same tenor and tone as a reprimand. So very, very important to try to work with your supervisors to get them used to documenting, and more importantly, spending the time, because, you know, this is a very important function. You can't possibly be aware of what every employee is doing, and you need to rely on your supervisors to stay on top of this and to do a decent job documenting. One thing I said before, just like looking for just cause provisions, look at your contract, see if there are any procedural or evaluation procedures in the contract that you need to adhere to. Again, sometimes you need to evaluate staff on a certain frequency. Sometimes you need to do an improvement plan. You just, again, need to look at the contract and see what other obligations that you might have there. And as we're moving along, I just wanted to show you here, there's a nice slide for you to refer to, again, for your knowledge and for the work that you might do with your supervisors, generally describing what a counseling memorandum is. And you find here, again, differentiating between a counseling memo versus reprimand. You know, usually the counseling memo is from a supervisor, not certainly the superintendent or the assistant superintendent. The directional letters to document misconduct and improvement, usually used for less serious conduct, and again, you know, the purpose of the letter is really to try to get the person to improve or to document what improvement is needed in the future. Some additional guidelines for writing a counseling memo and meeting with an employee. Again, you know, just generally some quick points for you to review and hopefully have already been incorporated in your practice. But again, you know, one of the important issues here is to make sure that counseling memos basically do end up in the distribution scheme in that employee's personnel file, unless, and I've had this happen, the district has agreed to a contractual provision that doesn't allow counseling memos to go into a file, or if they do, says that a counseling memo goes in the file for, say, 6 months or a year, and if the employee doesn't do it again, the file or the counseling memo is automatically expunged. I don't know why that language has ended up in contracts, because it really, if you think about it, it really defeats the purpose of progressive discipline to begin with. Because, well, you know, if that document isn't in the file, the employer's really going to be up the creek as far as being able to show that it's done any earlier work with that employee to begin with. And I'll always have a place on that counseling memo for the employee to either sign acknowledging that they received it. One mistake I've seen that, if the employee refuses to sign a counseling memo, it still goes in the personnel file. Just make sure that you jot down that the employee refused to sign it, put the date on the counseling memo, and it still goes into the counseling memo. So even if you have an employee who's being very difficult and doesn't want to sign it, you can still get it into the file in that manner, as long as you haven't given that right away through contract. Okay, some general guidelines here about, strategies for counseling sessions. I would say one thing again, use counseling in a very consistent manner. Counseling one employee continuously but not others, usually leads to a claim that you're picking or discriminating in some way against an employee. That can also be a weakness in a disciplinary hearing. You try to show all these counseling memos, and the employee and their union or representative are able to show that other employees have done similar things and they've never been counseled for that. And one last point, just be very wary of acting on the recommendation of a supervisor to counsel or take any kind of discipline concerning an employee without making a full check into what's actually happened. We've had some cases where, unbeknownst to the school administrator, a supervisor has some kind of a bias or a vendetta against a particular employee, and everybody knows it, but it's not in the record. And so, the administrator receives a recommendation to discipline and just acts on it without investigating. And later on in the proceeding, there's some evidence that the supervisor really acted improperly against this employee. So I think investigation, that's something that you've heard me talk about today several times, very important no matter, what type of an action you might be involved in with respect to an employee. Okay? So I am trying to close here. A lot of these last slides deal with counseling employees, some suggestions to alternatives to discipline, and I just want to close with talking about the fact that with all of these meetings that we've just talked about that may potentially lead to discipline, there are all kinds of rights, whether it's under Section 75 or whether it's a right given to unionized employees under the Taylor Law to have a union representative present at a meeting in which information that may reasonably lead to that person being subject to discipline comes out. So if you have any question at all that what you might be meeting with an employee about could potentially lead to you taking some action with respect to that employee and their employment, always err on the side of caution, especially dealing with a unionized employee, and make sure that they have that they're clearly put on notice right up front that they have a right to have their union rep there. For a Section 75 covered individual, that notice is supposed to be given to them in writing. Section 75 specifically says that an individual must be notified in writing right up front that they have a right to have a representative attend a meeting that could reasonably result in discipline. And again, as far as compliance, I think school districts are pretty lax on that point. So that's something, again, to go back and remind your supervisors of, that if they're scheduling meetings with employees who are members of a union, that they should be giving some written notice to them right up front that they have a right to have a union rep present. Okay? So I apologize. I seem to have come up a little bit long in length in terms of my outline, but I also want to make sure that we end the meeting today on time because I know that you probably have budget votes going on today in your districts. So I would just leave you with the idea that if anyone wants to contact me by email or phone about any of the remaining slides, most of which deal with some of the procedural issues under Section 75 that I'm clicking through right now, I'd certainly welcome your phone call. And I'm going to leave the rest of the time right now for any questions that we might want to have before we close today. Matt, are you still there on the line?
Yeah, sorry, I'm here.
Okay. I just wanted to generally see, based on a poll, do we have any questions that are outstanding?
We have no questions at this time, but if anyone has a question for Melinda, please hit 7# on your phone and be put right through.
Okay, and again, my offer stands, if because of the time of the day, if anyone does want to follow up with me, I'd be more than willing to reply. Just send me an email, or you can feel free to call me.
Okay, it looks like we don't have anyone on hold waiting to ask you a question. So everyone, thank you for coming today. I wanted to thank you very much for helping us out by agreeing to present. Your presentation was very great, and I'll see you all next time.
Okay, thank you very much. Have a great day, and good luck on the budget vote.
This conference has not started or has been paused by the moderator. You'll be placed on music hold until the conference begins.